and I recognize the member from Rothsay.
Hey. He can't help himself. Mr. Deputy Speaker, this bill, an act to amend the Gas Distribution Act, has some multiple facets to it, according to the government. I have in front of me a document called a news release, and it's from the Department of Energy and Resource Development, and it says, first line, legislation was introduced today which would end Enbridge, New Brunswick's $800 million lawsuit against the provincial government. It then goes on to say it reflects an agreement with the government to end legal action. And I'm quoting the Minister of Energy and Resource Development. This legislation removes the liability risk of more than $800 million from New Brunswick taxpayers. And so there's various aspects to this legislation. So if you may ask, what am I doing asking about it? I'm going to ask a number of questions around the subject of the lawsuit and issues with respect to ratepayers and taxpayers and things like that will be done by my colleague, the energy critic, my colleague, economic development critic, and others. So, for the purposes of my involvement with this bill, my questions revolve around and will revolve around the lawsuit. Having said that, I think my colleague, the member from Fredericton, York, suggested you may want someone from the Attorney General's office here, but as the Deputy Speaker said, the staff that you choose to have is within the discretion of the Minister and the Department, and presumably you don't feel it is necessary to have anyone from the Attorney General's office here. I respectfully disagree because, again, I'm not asking energy questions, rate questions, things like that. I'm asking specifically about the lawsuit and the legal advisors to the government on that lawsuit. It was done out of the Attorney General's office when I was Attorney General. I'm familiar with the lawyers who worked on it. I'm familiar with the province's legal counsel, and I'm familiar with the file. So again, I think it would be more constructive, but as was ruled, that's the discretion of the Minister. I'm a lawyer. I'm a former Attorney General. I used to have the responsibility for this lawsuit. I know legal counsel that's doing it. I've been briefed on it. I'm familiar with the law. And I just thought, in the course of my questions, the Minister may want someone from the Attorney General's office. So I make that offer to him again. I make it in good faith. And if we wanted a quick adjournment to summon someone, that's fine with me. And if not, I'll proceed with my questions. So I offer that to the minister again, and that's he can consult and come to any conclusion he wants. So I ask the minister if he wants to reconsider that.
To the honourable member opposite, certainly appreciate his interest in this file as former Attorney General for the province, and I'm sure that he understands the file that he had before him and the file that we have presently before us. But as he realizes that this is a matter that's before the courts, this is a litigation that's before the courts, and you know, at that point, Mr. Chair, it's something that we can't talk about. There's a lot of discussions that are taking place legally, so we're bound by that. So basically, we can talk here about the bill, and the bill is after the bill is signed off, then it is supposed to bring all the parties together to a legitimate settlement. But as far as discussions during the process of the suit, that's something that's before the courts, and we can't talk about it. But we certainly can talk about the bill itself, what the bill means for rates, what the bill means for savings to the taxpayers, what the bill means for stability as we go forward. There's a lot of aspects, as you mentioned before, there's a lot of aspects in this bill that we can talk about, but when it comes down to the actual litigation and the discussions that are before the courts, that's something we can't talk about.
I know a little bit about the law. You can talk about it if you want. You're just not compelled to. The privilege under solicitor-client relationship belongs to the client, not the lawyer. The client is every bit at liberty to waive that if he wants. So it is handy to hide behind, but you suggest that it's a mandatory thing, and it is not mandatory. It is available to you, and your privilege is yours, and you can do what you wish with that. So to suggest that you can't talk about it because it's before the court is not accurate. I think what is accurate is your position is you won't talk about it because it's before the court, but there's nothing preventing you from doing that. And given your government's position on open and transparency and openness and all of the stuff that you campaigned on, I find it kind of peculiar that you wouldn't answer some of my questions. But in any event, I'm going to forge ahead and ask some questions. The settlement of this lawsuit and the genesis of this bill, did that come from your department, or were you advised of that from the Premier's office? I mean, did you say to your deputy, let's take a look at this Enbridge business and see what we can't do, and then report the results of what you want to do to the Premier's office? Or was it reverse? The genesis of this arrangement came from the Premier's office, and you're here defending it. Could you tell me which one it was, please?
Yeah, to the member opposite, appreciate the question. Basically, it starts with the department, goes to a cabinet committee. It's part of energy policy, the content of the bill, and it all originates from my department as we go forward. And the department at the time was the Department of Energy. Before I came along into the picture, it was already in process with the Department of Energy. And as the member opposite knows, they've been charged with dealing with the Natural Gas Act and bill that was enacted in 1999. So it's been part of the mandate of that department to handle the energy policy and everything around that. Now, just you know, I was hoping that the member opposite would have taken the opportunity, the same opportunity in the olive branch that was extended out, to get a full briefing on the file because, you know, it's good to read the bill from the other side, but at least to have the opportunity to question staff. And this bill was put on the floor of the House, I believe it was first time reading was November the 8th, 2016. And if I recall, it was either that day or maybe the next day that the settlement agreement was tabled in the House. It was actually tabled in the House, and the amended and restated general franchise agreement was all tabled in the legislature at that point in time. So, you know, there's been ample opportunity to question it. There's been ample opportunity to add advice to it, ample opportunity to have further questions. And, you know, Mr. Chair, you know, the realization that this was probably a hot button topic with the opposition because basically they're the ones that changed the act, ripped up the old agreement to get to where we are today, and now all of a sudden there were no questions on it. I was accused, I think it was 2 days in question period, last week or the week before last, of not answering the questions, but the questions had absolutely nothing to do with the legitimacy of the bill at all. There was nothing on the bill whatsoever. So I hear what you're saying as the previous Attorney General, what direction you want to take this in, but basically the same stands. I mean, this is it's a matter that's before the courts, so the discussions that take place with client and the legal firms is confidential. But the content of the bill that impacts ratepayers and the end result, if the lawsuit did go through between the plaintiff and the defendant, if something were to take place there, then who's responsible for that? Is it either the taxpayer or is it the ratepayer? So there's a lot of uncertainties out there. And I remember the day before yesterday, because we were ready to come up in the House yesterday, and the day before yesterday, I guess it was a running of the clock, where the member opposite, the critic for this department, was talking about, by golly, we've got a suit, you guys should have hung into it, you should have stuck it out, you should have wrote it out. And the question that I have is, how much do you go? How far do you go? He was talking about a fishing pool in his area, that there's a lawsuit that's outstanding. There were some comments that were going back and forth about, at the time yesterday, we were talking about government reorganization, and I was asked about costs, and you know, it was I'm trying to think what the term I used. It was a small amount that I was referring to change some of these departments. And one of the members picked up on that and said, there's people that are living day to day, trying to get by, trying to live day to day, and you call this a small amount. I can't remember the word I used. I'll have to check on it. But the point is, we've spent $4 million, if I'm not mistaken, on this lawsuit so far. $4 million on this lawsuit. Should we drag it on? Is this something we drag on and on and on? Because it's a chess game. It's a huge chess game. We only have so much resources. And I know that the member opposite has been before the courts a good many times. I haven't been before the courts a good many times. I don't know a lot about law, but I do know the critic, the member opposite, felt that we should fight, should stick it out. Well, I've been involved in 6 lawsuits when I was in business, and I can't remember if 3 or 4 of them I launched, or 2 or 3 or whatever it is were pushed against me. And I remember having the attitude that the member opposite, by golly, I'm going to fight this right through to the bitter end. I'm going to fight this. I'm going to win this, by golly, because I know I've got my cards. I know everything in hand. I'm going to win this. And by golly, I'll tell you something. I remember the judge saying to us in the first day, the judge said, you guys should go have a coffee and talk about this before I make a decision. And I just gritted my teeth. I said, I'm going to win this. And by golly, we went back to court that afternoon. He rendered a decision, and it was against me. Well, guess what? The 5 suits that I was dealing with in business after that, by golly, I'll tell you something, we all got together and had a coffee after the fact and said, how do we appease this? How do we establish dialogue? How do we work together so it doesn't get to discovery, so it doesn't get to that stage of being before a judge? Because in this particular case, we had no idea We couldn't prejudge what a judge was going to do. We just knew that this was something that was before the courts, and it was in the best interest to settle this. It was in the best interest to have some discussions so that we could move on. The potential risk was $820 million, a significant amount of money borne by every man, woman, and child, whether they burn gas or not. That's $1,100 per person. Now, $1,100 per person. So do we send a bill out to every person and say, look, because of this? Instead, we were able to work to settle, come to an agreement to work towards a memorandum of understanding to pass legislation so that we could move on, put this behind us. At the same time, it builds on that stability factor. How do we get stability back into the system? And I know the member opposite yesterday was talking about, you know, their business plan called for 70,000 people, and they were wrong, and it was flawed, and you know everything. You know, the sky was falling, and you know he was taking spaghetti and throwing it against the wall. Whatever stay there is the fact. That was fact. But the fact of the matter is, we're dealing with the situation at hand. 12,000 ratepayers had this suit over their head. We had a company that halted doing any expansion work, doing any type of work to grow the pie anymore. And we had ratepayers that all they could see was instability, complete instability throughout the system. So it was in our best interest that we find a way forward on this. Instability doesn't do a lot for us. If there's stability, and if we have a company that wants to invest, wants to grow the pie, understands they're in a competitive market, because people do have choices. People have lots of choices here. They can use propane, they can use oil, they can use electricity. There's a number of avenues that they've got to turn to. And we all know that Enbridge do not want to price themselves out of the marketplace. You know, going forward, they don't want to price themselves out of a marketplace. So they feel it's in the best interest, and we feel it's in the best interest. Let's move on. Let's get this behind us. $820 million to every man, woman, and child, whether you burn gas or not, is quite a significant amount of money, Mr. Chair. So I think it's in our best interest as a province that we did establish dialogue and move forward on it. So I don't know if that kind of answers the questions, but to what the member opposite would want to bring forward. But definitely the bill is here. The terms of the settlement agreement are right here, and this was all tabled in the legislature. And I don't know if you've had a chance to look at it. I certainly encourage you to look at it. The other side of it is I encourage you, and my staff, we'll have our staff to reach out and actually have a complete technical briefing on this, so we all have an understanding, a mutual understanding of where we're going and what this means. You know, what does this mean what's it mean for the ratepayers? What does it mean going forward? How do we get moving on this? How do we grow the pie? So I don't think I answered your question. Obviously, I didn't answer your question, but I just wanted to make those points. The importance of why it is we need to settle this, why it is we need to move on. You know, Mr. Chair, I've had a number of businesses wondering about natural gas in the province. Where can they plug into? Is there an opportunity to grow? And Mr. Chair, it's made for, you know, difficult conversations for some companies that want to have some stability in that side. So on that, I'll sit down, and I think maybe you might have another question.
My goodness, Minister, you've been around the member from Dalhousie too long. That was quite a work of art. My question wasn't answered, and you took a scenic route around a number of things, and I'm telling you, I thought that the member from Restigouche Campbellton was in a league by himself. But I'm not sure that that's true anymore, so.
I think they're roommates.
you know, the suggestion that, you know, we could have had a briefing or something, that's why we have committee. I mean, you go to committee and you ask questions, and it's on the record and things like that. And to say that you're not going to answer a question in committee because you've offered a briefing, that's not legitimate. That defies the rules of the legislature. It's not appropriate in its answer. It's not substantiated in law or in procedure to say, well, I'm not going to bother with this in committee because I gave you a chance to have a briefing, therefore I don't want to talk about this. So your answer is not, again, it's well, it's what it is. My question was, things in government, issues in government arise either in a department or policy that emanates from the Executive Council. The Executive Council says this is a policy of the government, this is what we said we would do, this is what we want to do, so they go to the particular department of that particular subject. Or there's things that get their genesis in the department. The deputy minister goes to you, you're the new energy minister, and said, Mr. Minister, look, this Enbridge deal, it's a terrible deal, shouldn't have done it in 2011, I think it's awful, let's fix this. And from there you start procedures, start negotiations, and you advise the Executive Council as to what you're about. Now, those are the only two places that policy starts in government. It starts at the Executive Council and works its way to the department, or it starts at the departmental level and works its way by way of a MEC to the Executive Council. Either way, it gets its genesis somewhere. The seminal moment is somewhere. And my question is, did this come from the Premier's office and the Executive Council office, or did it come from your department? It had to start somewhere. The Department of Energy and the ECO people, Premier's office, didn't wake up the same morning, the same little light go off and say, let's do something about Enbridge. Now, it started somewhere. I simply want to know where it started.
To the member opposite, always good to have an exchange in the House. I just feel terrible because I feel I should get up and not say the honourable member from Rothsay. I feel like calling you Ted, so excuse me. But the honourable member from Rothsay, you know, I have to tell you something. I've got to tell you something. I don't know if I'm humbled or what when you said, take it, you know, that reminded you of the member from Dalhousie. So I don't know if I should take that as a compliment or what, because I have great admiration for the member from Dalhousie too, Mr. Chair. I mean, I think he's a wonderful person. We first came into the House in 2003, but I'm not going to get into that historical side there, Mr. Chair. But I definitely, for the time being, I'm going to take that as a compliment, as a wonderful compliment. So I thank you for that. So back to the bill. You know, when we talk about the bill, I mean, this matter has been ongoing since 2011, okay? It's a responsibility of Energy and Mines with the policy side of it. There's been continuity between the previous government and this government. The new government form, the status of the natural gas distribution file was before us, the same way it was before you people. The department has continued to this day to provide policy advice as we go forward. So it's been in the hands of the department for a number of years. It's been in the hands of the department since 1999. So the advice and directions have been coming from the department for ongoing discussions. And I do believe I mentioned in the House that the discussions have been taking place before the changeover of government. That there was dialogue, there was discussions that were taking place. And those discussions that were in continuity have led to where we are today, which is the proposed piece of legislation that's before us in the House. So today and before, it's basically the continuity, the process of where we got to today. I'd certainly love to get into the legislation, and I know that the member from the Green Party, he's eloquent, very eloquent at looking at the bill that's before us in the House, and had the experience yesterday, and he pointed out some things that were very, very interesting. I mean, he took the time to actually read the legislation, and this piece of legislation, Mr. Chair, is pretty deep, and I would say that somewhere along the line, the Telegraph Journal was critical because I didn't give answers. Well, to tell you something, I was never asked the questions. So I'm hoping that sometime today we can talk about the deal, go beyond the $820 million savings. Let's go beyond what it means for ratepayers. Let's go beyond what it means for the caps until 2020. Let's go beyond 2020, what that means. Let's talk about the deal. It's a standard deal. This is a deal, any utility, its normalized utility is a 20 and 20-year contract or a 25 and 25, and every jurisdiction across North America is the same thing. When you go through the expenditure, the capex of putting pipes in the ground, you have to have something for amortization over a longer period of time. So this is pretty standard in the industry. So I'd like to be able to read into the record something about the deal, because I think it's important that we're banding around the legalities and this and that and all kinds of other issues here, but what the people want to know is, what does this mean? What does this really mean? Besides the $820 million that's off of our shoulders, which, by the way, had we lost that, we'd be on the hook to pay that immediately. Mind you, we'd probably appeal, and then appeal, or vice versa, plaintiff or defendant. There'd be an appeal process. So it'd be hung up in the courts for years and years and years. And is that what we want as New Brunswickers? Is that what the ratepayers want? Is that what the taxpayers want? They'd like to have some stability. So on that, I think I did kind of delve into your question a little more with the fact that you'd asked me about where it was, and it's been sitting with the department, and the policy and advice came from the department. Am I okay?
From my experience in previous government, the people in the department were very much in favor of the 2011 legislation. They supported it, they presented it, they said it was the right thing to do. It's my memory. What then, if they supported if they were supportive of this piece of legislation in 2011, they signed the MEX, they presented the thing, it was recommended that they should do it. Perhaps you could enlighten me then as to what occurred in the last couple of years that would have the department reverse what appeared to be their position on it. So we'll hold that question for a minute. I just also want to say again that I told the minister that my questions were of a legal nature with respect to the lawsuit and the legal aspects. I asked him, this will be the third time, I know what goes on in departments, and I know you're responsible for this and this. A gargantuan change in government policy occurred. The 2011 legislation, which this act changes, is significant. It completely reverses what had been done in 2011. Significant. My question is, for the third time, did the genesis of this come from the Premier's office or did it come from the department? Did your deputy come into you and say, we have got to change this Enbridge thing, we need to unravel what was done in 2011, and then from there advised the Premier's office and the ECO that this is what you were about? Or was it the reverse, where the Premier's office said, this is what we're going to do, and they instructed you to do it? It had to start somewhere. The genesis for this significant about-face had to start somewhere. My question is, and I'll eventually find out, but my question today, did this policy change emanate and get its genesis from the Premier's office or from the department? Now, I've asked that question 3 times. I've gotten the Restigo shuffle 3 times. And I want to know the answer. Because you know the answer. Your deputy knows the answer. The people behind you know the answer. Now, where did it come from? Did it come from the Premier's office or did it come from the department? And you know the answer. I'd like you to tell me.
To the member opposite, and you know, member opposite, one thing I find about him is he's very patient and very eloquent in asking his questions, and I know maybe getting a little excited at the same time, but that's okay. That's okay. Certainly understand that. But you know, the answer is basically the same. It is the same. I think I answered it 2 times. The gargantuous, is that the word you use? The gargantuous issue was changed in 2011. That's when it happened, was 2011. So discussions have continued since that point in time. And long before I became minister of the department, there were discussions that were ongoing in our department with respect to policy framework, and they've continued to deal with the natural gas file because it was part of our mandate. But what we're doing with this piece of legislation is we're returning to a regulatory framework that is a move that's more commensurate to today's standards in any utility. I mentioned about the North American, there's a standard that's, you can't go into a company and say, okay, come here and set up shop, and we're going to give you an amortization period of 10 years. And then I hear the comments from the member opposite there talking about monopoly. But it's standard. This is standard. It's, you know, 25 and 25 is a standard. So, in answer to your question, this is something that staff have been dealing with in our department. I don't know what happened in 2011 at the cabinet table because I wasn't there. I can assume there was a few eyebrows that were rolling because there's some people that sat at the cabinet during 2011 that had a business sense and said, is this really the road that we need to go down? Can we have discussions? Can we establish dialogue? But look, everyone is entitled to their opinion as to how they deal with something, where they go with it, Mr. Chair. But like I said, this gargantuous situation started in 2011, long before I was involved. As a matter of fact, none of the staff sitting here today were there. So basically, like I said, what we're doing is we're returning to a regulatory framework that's commensurate with today's standards. So we're going to return a utility to where it should be, Mr. Chair, a regulated utility.
It reminds me of the old saying in Carleton County when a fellow said, did you ever try to pick up an eel in a bucket of grease? And you're pretty slippery, and you're not answering my question. and you're intentionally not answering it. I've asked the same question 3 times. And it's a simple question. And it's an easy question. I know you know the answer, and I know the 3 people around you know the answer. And talking about, oh, the change came in 2011 and when the change was, the legislation of 2011 and what is before this committee is a significant and dramatic change in policy. Now I can ask the same question again. Did that change in policy come from your department or come from the Premier's office? And you're not going to answer it. So I'm going to assume that your waffling around leads me to believe that it came from the Premier's office. So unless you stand up and tell me that it did not come from the Premier's office, then I'm going to conclude that it did. The minister informed the committee who represented the government, and I want individuals and their names, who represented the government in these discussions with Enbridge. Who was your lead person on it?
To the member opposite, appreciate that question, but my lead people that I've been dealing with on all policy and directions in the department have been my deputy and senior staff that have worked on this file, Mr. Chair. And that's who's been working with me. Like I said, there was some discussions that were taking place prior to myself being sworn in as minister, but those discussions were ongoing. This gargantuous situation started in 2011, and there's been discussions since then. Like I said, I wasn't at the cabinet table when you folks were there as to how you made the decisions on this, but discussions were taking place with you people, the continuity as ourselves. So it's been with my staff since I came into the picture. Maybe my learned colleague from Dalhousie Restigouche, we could have a little conference and say, well, what did you know, what did you did not know? But the fact of the matter is, we have a bill that's before the House that is basically ending this lawsuit and wiping the slate clean so we can move forward, so that the erroneous amount of money is not on the taxpayers anymore. Instead, we're working with a settlement that sets some stability for the 12,000 ratepayers that are on the system. And stability is what people are looking for, Mr. Chair, is let's work together and find some stability. And how do we grow the pie? How do we make sure there's costs out of it so we can continue to grow the pie? Because at the same time, we all know that we have choices. I have choices whether to burn electricity, burn wood. It seems to me the natural gas line is about a quarter of a mile from my home. Is there going to be an opportunity where I can plug into that? The fact of the matter is that we all have choices. And the genesis of this settlement is the fact that let's work towards that stability side so that we can become competitive and compete in a competitive marketplace. I don't think they're going to be outpricing themselves. That's not an issue here. I don't think they're going to outprice themselves so they have no customers. They're interested in growing their customer base. So the discussions were long before I came along, and it's been continued. And I've worked with my staff on the file on a number of fronts where it's come forward from continuing from the previous minister, because I've only been on this file since June. So it was part of our ongoing discussions and briefing sessions that this was ongoing. So, at some point in time, you have to put it behind you. And that's why this bill has come forward. Bill 6, an act to amend the Gas Distribution Act 1999, has come forward.
Well, once again, my question was, who is the lead government person on the file dealing with Enbridge? And you then answer the question by saying, these are my lead people in my department. Question not answered. Question just wasn't answered. I've been around business, law, government all my life. I've negotiated with government from the private sector's point of view. There's always a group, a lead group that you deal with that has to, the front people, that lead people that dealt with Enbridge. Were there people from the Premier's office in that group that dealt with them directly, or was it done entirely by your department? It is a simple question. Simple question. I'd like a simple answer.
To the member opposite, I don't know if we're going on 5 times or 6 times, kind of lose track, but the leadership on negotiations for this total file have been held by the department, and the negotiations and discussions with Enbridge have been by the department. Same as the previous government to get to the stage where they were at. So it's been through the leadership and advice, the policy advice from the department, which has led us and got us to where we are today, which is this bill that's before the House, which is Bill 6, an act to amend the Gas Distribution Act, 1999. So I don't know if I should write it down on a piece of paper. I mean, sometimes if you try and try again, you know, but the thing is, it's the same people getting the same results. But, Mr. Chair, this is a fact of the matter. It's been by the department, led by the department. The continuity's been by the department. And, you know, you're entitled to your opinion, and you can make your assumptions, but this is the facts that are before me, that policy advice and policy drive has been from the department.
Well, you know what I'm after, and you're not prepared to give me an answer. My questions have been clear. They've been precise, and I get this around the Mulberry-Bush policy and this and that and blah, blah, blah. So I'm relatively satisfied that you're not going to answer my question or any of my questions so far. And by virtue of your refusal to answer, it leads me to conclude that my initial impressions are correct. When you were advised by the people in your department about this issue, what were the circumstances, or what was the new information, or what was the change of a department that supported the 2011 legislation and then a department that now supports this? What facts would have led you to believe that what was done in 2011, which was recommended by your department, would conclude you to believe that they feel that that's a mistake and was wrong and shouldn't have been done?
To the member opposite, frankly, I wasn't there. I wasn't part of the discussions before that as to what, if anything, changed on this matter. The fact is, Mr. Chair, it was important that we establish some dialogue, and as it turns out, it was continuity of dialogue that really needed to take place so that we could come to a good settlement, a good agreement, so that we could take that erroneous $820 million that was on our shoulders off every man, woman, and child's backs. And how do we move that forward? How do we get to the stage where we can have some dialogue and start getting ourselves back to a regulated utility that we need to be at, Mr. Chair. And, you know, the discussions that took place with the department led us to where we are today, which is this bill, to put this bill in place. And this bill spells out the settlement of how we move forward as a province. With 12,000 ratepayers that have been disillusioned by what's taking place in the marketplace, not having stability for the small ratepayers right through from the small, large industrial users to have an understanding of where this was going. Was this company going to be around? Were they going to just pick up the pieces and leave? So we really need to get ourselves to a stable environment where we have stability as a utility. They're no different than NB Power. They're no different than a bus route when you're dealing with the Energy and Utilities Board as to how you move forward on rates. So I think the importance, the genesis of this, the importance that we get this behind us so that we can start moving forward.
Mr. Minister, stability to the ratepayers is what the 2011 legislation did. Enbridge basically built a 20-unit apartment building, and they rented 4 apartments. They thought they'd have 70,000, and they had a fraction of that. So if you build an apartment building, you build a 20-unit apartment building, and you only rent 4 apartments, who should be on the hook for that? The person who built it? The person who didn't get it right? The person that overbuilt? Or should it be on the backs of the 4 tenants that he did have? The residential people pay about $7 million a year, and you're saying under this that you're allowed increases of $4 million a year? I'll tell you, if you're paying $7 million and you get an increase of 4 per year, and another 4, and another 4, and another 4, it's pretty dramatic. But in any event, I have some notes here. The minister was asked about this issue. And question period several times. Each time he comes back to the lawsuit. Instead of talking about, you know, the fundamentals of the issue, who's going to pay, what's going to happen to rates, why does the public intervener think that rates are going to go up? Why? You come back to the lawsuit. And I'm quoting from Hanson, we just settled on an agreement. We settled a lawsuit of more than $820 million. Had we lost that lawsuit, terrible. That's gone, and that's a good deal for taxpayers. Another time, asked a question on the merits. The fact of the matter is that $820 million, an enormous amount of money, was going to be on the shoulders of taxpayers if we did not settle. Sounds to me, by that answer, that you'd concluded you were going to lose. Another day. I'm really proud of the fact that our government sat down and got rid of this lawsuit. It was going to cost every single taxpayer in this province a lot of money. So it's pretty clear from the record that the minister held the position that this lawsuit was a serious liability, conducted himself as though he was going to lose, and governed himself accordingly. What legal advice did the minister get which would be different than the legal advice that I got? the legal advice that I got from the Attorney General's office and from counsel was that the lawsuit was frivolous, was not sustainable, it was barred by statute. Section 52.51, 52.52 of the 2011 statute is worth reading into the record. And I read it. Now, as a lawyer, if I was defending someone who had this statute as a defense, I'd be pretty happy. Now listen, 52.5 applies to Enbridge. No cause of action arises, and no action or other proceedings for compensation, damages, or otherwise lies or shall be instituted against the minister, the Crown and right of the province, or any employee, corporation, agency of the Crown, as a direct or indirect result of any of the amendments to this Act enacted in 2011, or any regulations, orders in council, board orders, ministerial orders, directives, or otherwise made under the authority of this Act and enacted in 2011. The next section says, 52.52, an action or any other proceeding that was commenced before the commencement of this legislation, and that is directly or indirectly based on or related to the amendments to this Act enacted in 2011, or any regulations, orders in councils, board orders, or ministerial orders, or directives made under the authority of the amendments to this Act enacted in 2011, is deemed to be discontinued and abandoned without cause. So Enbridge was suing the government. Enbridge was suing the government, and the government has a duly enacted statute that bars them from what they were doing. This statute and statutes like this have been approved and endorsed by the Supreme Court of Canada. Our legal counsel told us that it was inconceivable that their action could succeed, that it was frivolous, it was a tactic. Attorney General's office told us that, told me that. So what was frivolous and nonsensical, barred by statute, sent quivers down the spine of the minister. What legal information did you get that said this lawsuit had any merit or any potential or any substance? Because the best legal counsel in Eastern Canada, the full force of the Attorney General's office, everybody who's ever looked at it, has concluded that based upon the bar in the Act, that the action was without basis. Provincial legislatures, it is perfectly within their authority to bar a legal action. No better example is the Limitations of Action Act. If you want to sue somebody, you've got to sue them in 2 years. Beyond the 2-year period, you're out of luck. You're not allowed to sue. Well, people who've missed the limitation period, they say, well, my rights are, but no, they haven't. Because that's the law, and the Supreme Court of Canada says these clauses are valid. Now, something happened. Because if you quote the minister in his answers, he's of the opinion that the lawsuit was bound for success. You don't need to be a lawyer to read those two sections. The law says clearly that the action is unsustainable and unwinnable. What's with the big change? Could you please explain? Did your legal counsel have some kind of a cathartic moment where they all got up and said, oh my gosh, we're wrong, we were wrong all along, everything we told Attorney General Flemming, everything we told the government, it's wrong, it's terrible. We now think we're going to lose. Well, if that's the case, I can understand it. So would you please tell me what legal advice changed from you now have a serious problem when a little over 2 years ago it was a frivolous lawsuit?
So to the member opposite, interpretation of any law or legislation is done by the court, and such, even if the government feels and thinks they have ironclad legislation to prevent or protect against a litigation or lawsuit. 5 years later, we continue to have legal action in this matter before the government. So, Mr. Chair, in the meantime, 5 years later, we have ratepayers, we have residential, we have industrial, we have potential customers to grow into that base of 12,000 people, Mr. Chair, that have been in limbo. They've been in limbo for a number of years, wondering what is going to take place. It's been unpredictable. They want to grow their businesses, or they'd like to have natural gas to continue the operations of their homes, their businesses, and that type of thing. So I think for the 12,000 ratepayers, we owe this to them. We really owe this to them to get this behind us and get some sort of a settlement in place. I know you want to spend time on the fringes in an area of a legal matter and the details of the legal matter, which we're not authorized to talk about because it's still before the courts. But I'm hoping at some point in time today there might be a question about the bill and what it means to, yeah, I know you pointed that out. I was hovering around the lawsuit, and you don't want me to talk about that. You don't want me to talk about the $820 million. So I'll try to refrain from talking about the $820 million that's on the shoulders of every man, woman, and child. But maybe parts of the bill, let's talk about stability for the 12,000 ratepayers as to how they go forward for the next 3 years, 2 or 3 years, up until 2020. Rate caps of 3%, 0% for the industrial, and then what takes place after that, and it's the Energy and Utilities Board that will make the decisions, and it'll be based on the revenue requirements of the utility. So I'm not sure. I think the member opposite wants to keep going on that point for a while now, but that's okay. That's okay. You talk about a frivolous lawsuit, but that's fine. That's your opinion. It's the opinion on that side of the House. On this side of the House, I think it's important that we establish dialogue, which we've done, so we can draw an end to this, so we can start working together on how do we protect the taxpayer. At the same time, how do we have some protection for the ratepayer so they can grow their business? Simple as that. And economies of scale. The more people that they have in the system, on the downflow system, the more people they build into that system, the better off they'll be with revenue requirements.
Well, we saw what happened to the ratepayers in the past. We saw the massive increases that they got. People were astounded at how high their gas bill suddenly became. The ratepayers had stability in the 2011 legislation, and they do not have it now. And to limit it to 3% for 2 or 3 years is nothing more than getting yourself beyond the next election without it blowing up in your face. In any event, I would like to question the Deputy Speaker on timing. It is 2:45. If we are finished on this bill at 3 o'clock, I think I would like to have the member of the third party have a fair opportunity to ask some questions. And so, am I correct that this ends at 3 o'clock? Because I'm just doing the lawsuit. We have got lots and lots and lots of questions of a substantive nature, which the minister seems quite keen to get into at some point. So are we done on this today at 3 o'clock?
So my understanding is that there's an agreement to set this bill aside at 3 o'clock?
Okay. Having said that, it was going to be set aside to 3 o'clock. I believe I would like the leader of the third party to have ample opportunity. I've kind of hogged it till now. And if he would like the rest of the 15 minutes, or 10 or 5, whatever it is you feel you need, I want to accommodate the member of the third party to the fullest extent. From now till 3?
The chair recognizes me, I will. Okay. Recognize the member from Fredericton South.